You've heard a lot of our members who ask you about an application for a search warrant. I gave a copy of that application to your staff before this hearing, and I think they have it to present to you now. But for the record, it's case 1:10-MJ-00291-AK document 20. With the Chairman's permission, I'd ask that that be made a part of the record of this hearing. And,
without objection, so ordered.
And, Mr. Director, is it not true that the standard for arresting an individual for committing a crime and the standard for charging an individual for committing a crime are both probable cause?
Yes.
If indeed that is the standard for arresting an individual and charging them with a crime, in this application for search warrant that we presented to you and have you've been questioned about several times today, your Special Agent, Reginald B. Reyes, certifies in this application that there is probable cause to believe that the individual involved in here, which was James Rosen, had committed or is committing a crime. And yet your testimony, as I understand it today, is that there was no potential for prosecution. My question to you today is, if you have an individual that you know has reached the standard for arrest, the standard for charging with crime, and one of your agents has attested to that, how can you say, what standards does the Department has that says that there is no potential that that individual will be prosecuted?
There are a number of occasions where we may have probable cause or facts that would purport to establish probable cause to charge somebody with something, and we do not.
No, I understand that. I understand that. But how do you say, before you even get the evidence, that you've reached that standard to charge someone to prosecution, how do you say that there is no potential that you will prosecute this individual when you haven't even obtained the evidence to know the extent of that crime?
Happens a lot of time when we include search warrants, and we've got cooperators who are.
But in this case of Mr. Rosen's, can you tell us if he was cooperating or if there's any guidelines with the Department?
That was not my response. Was to your question before.
Okay.
That there are many occasions.
In this occasion with Mr. Rosen.
Finish, sir. There are many occasions where you have probable cause to believe a person has committed a crime, and you have no intention whatsoever.
Absolutely, I know that. But in this case, can you tell us what guidelines would allow the Department, allow you to testify today under oath, that there was no potential to prosecute Mr. Rosen if your agent has said that you had probable cause to charge him and to arrest him, and you had not even gotten the results from the search warrant yet?
I'm not certain I understand the question.
Then let me rephrase it and be very specific. You have stated that there was no potential for prosecution for Mr. Rosen. Was issued. At the time this search warrant was issued, your agent attested to the fact that there was probable cause, the standard, to both arrest him and charge him. Yet your statement is that there was no potential for prosecution at that time for Mr. Rosen. And my question is, what guideline or on what basis do you say there wasn't even the potential of prosecution?
I go back and look at my answer, but I am not certain I stated it in that way.
So then would you say there was at least a potential for prosecution when the search warrant issued?
I am not going to say that because I am not the prosecutor on the case. I did not have the case, and those decisions are being made by.
I know they'll ultimately be made, but how can you can't state today that there was no potential for prosecution, can you?
I'm not going to state it one way or the other.
Okay, let me ask you this question, then I'll shift totally because you don't want to answer that question.